Hello, everybody.
All right, this is case number 10-5669. This is Aaron Financial Services LLC versus David Williams. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this case on the 10th of August 2010. That judgment was renewed subsequent to that time. Looked like that renewal was 7/20/20, and the judgment balance at the time was $1,986.46. All right, your appearance for the plaintiff in this matter. For Aaron Financial, do I have David Williams?
Yes, sir.
All right, thank you, Mr. Williams, and good morning to you. I that you have filed with the court objections to a writ of garnishment. I also know. All right, counsel, are you here on Aaron Financial?
Yes. Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Okay, all right. Somehow I called for you earlier and didn't get a response. But thank you, counsel. I see the objections to the writ of garnishment. I also see a motion to set aside a default judgment in this matter. All right. So let me first address the motion to set aside the default judgment. It says that 21 days have passed, but I've not been personally served. And I have good cause for setting aside the default in this matter. I'm looking at the file, and just one moment here. Contained in the court's file from 2010 is an affidavit of service by posting as allowed by the court at the address on Penrod to Mr. David Williams. Personal service was not required because the court allowed service by posting. All right, so the issue of personal service is not an issue in this case. Moreover, it's been 15 years. And this is the first instance of a motion to set aside a default. So what are you talking about, Mr. Williams?
This is my first time ever hearing about it. When I got the written garnishment by my employer, I never knew. I wasn't even in Michigan at the time when they were saying they was trying to serve me. I stay in Florida, sir.
Yeah, well, the judge at that time, many years ago, allowed the service by posting. So that is good substitute service.
But how can I? I'm sorry, sir, but how can I dispute something that I didn't even never know about?
I don't know, but no, ma'am, you can't say anything at this point. Over several years, there were several notifications of garnishments against income tax involving your social security number over several years, back in 2010, 11, 12, so on and so forth. And so 15 years later is when you come forward and say that you never heard anything about this. And of course, the information that you provided, even as it relates to your objection, that certainly does not have a Florida address. So I don't think I see a basis for setting the judgment aside. I'll address the other issues in a moment. Let me hear from Mr. Johnson on this, sir.
Yes, Your Honor. Thank you. Based on the defendant's motion, he was under the impression that we had the Southfield address for 15 years, and it's just not true. It was served appropriately back in 2010. and we've renewed the judgment. We are way past any type of reasonable time to talk about setting aside a judgment that has been renewed.
Yeah, it's just, I just don't see a basis that would allow me, although, I look for that. I don't see a basis that would allow me to set this judgment aside. There's just no basis to set it aside at this point. So that motion in that regard will be denied at this time. Just, I have to have a legal reason, and I have no legal reason for setting this aside. So I can't set the judgment aside. Now we deal with the objection to the writ of garnishment. The objection to the writ of garnishment says, I never received notification until 15 years later. I never had a chance. My address that's not my address. I believe the information is fraudulent. You can't even raise that in the context of an objection to a writ of garnishment under the court rule. So you don't have a valid objection to the writ of garnishment. Legally or factually, do you have a basis for setting aside the garnishment? So let me ask you, sir. It looks like you work for OWI or CWI Logistics. Is that correct, sir?
That's correct, sir.
So has any money been taken from you regarding this case?
Yes.
All right. So how much? So do you get paid weekly, monthly, or twice a month?
I get paid weekly.
All right.
I'm sorry, go ahead.
I'm trying to find out how much has been taken from you in terms of weekly under this garnishment.
It's $168 a month. A week coming out of my check.
All right.
And I'm not even getting 40 hours.
Got it. So that's hitting you for this one more 4, 5, 6, about $700 a month, right?
Yes, sir.
All right. This
And may I say
judgment.
May I say something? Okay.
Yeah,
Yes.
and just a moment. Yeah, this judgment started out as $1,800 back in 2010. Counsel, what are you showing as a balance on this judgment this time?
Your Honor, I'm showing a balance on the judgment today, $5,530.61.
Have you received any payments on the judgment, sir?
Yes, Your Honor, we received a check. Well, we received it March 11th in the amount of $125.60. And then, hold on. Then March 18th, we received an additional check in the amount of $145.52.
All right, so any other payments that you're noting over the years, sir?
No, Your Honor, as the court can see from the record, there've been like 30 a lot of garnishments issued, unfortunately. And this does happen. This is the first one that actually hit where it was successful.
All right, sir. So I know I'm on the record here. Have the parties talked at all in a breakout room to see if you can reach some kind of way of resolving this? Because what happens is that the judgment been in place 15 years. You got interest accruing on that, and it started out at like $1,800 or $1,900. The defendant is saying one of the issues here is that he did not receive notice legally, and there's a difference between legal notice and actual notice. Legally, I find that there's notice, but he's saying that he didn't receive notice. So it probably, here are two things I'll say for you. It's probably worth talking to see if you can come up with a number that resolves the case, something less than where it is now. The other thing, just listen to me. You can do whatever you want to do. I want everybody to understand that except for when it comes to the law and what I have to do, I'm gonna do what I have to do. You can do whatever you want to do. I'm gonna do what my responsibility is to execute the law. Sometimes I can give people some direction as to how you might be able to resolve it. You don't have to listen to me when it comes to that. I issue orders, but I know right now that what you're dealing with is a garnishment that's going to hit you for $700 a month. I can tell you that I will likely grant something less than that amount so that you're not able to garnishment that high. But maybe you can find a way that both parties talking to see if you can get away from that $5,500 that this has blown to. Okay, that's the only reason I'm talking about. Listen to me now.
I'm sorry.
That's the only reason I'm talking about this now, to try to see if there's a way to help you going forward with this. That's all I'm trying to do. You may disagree with my rulings on the other stuff. You can always appeal me. You can always file something else. But hear me on this part of it. Okay, this part of it is if nothing changes here today, that garnishment is going to stay in place, and you're going to get hit for $700 a month. I will reduce it.
Can I speak for a second?
Do you understand everything I'm telling you?
Yes, sir, I do.
You speak and you tell me something that's crazy, then I'm going to be stuck with what you're telling. Go ahead, I'm listening.
No, sir, I'm not going to tell you anything crazy. Right now, like I said, I'm not even getting 40 hours a week. I'm the primary breadwinner in my house right now because my wife is battling cancer, and that is going to really, really put me in a bad situation. I have a child. I'm not telling you anything crazy. I understand that, you know, what your judgment is, but I was just asking is there any way possible that could be, reduced or something, because that's going to really put me in a bind.
Absolutely.
Especially after 15 years when I could have been paid this. He's talking about there's been failed garnishments, but this could have been resolved. I didn't know anything about it. This is my first time ever even knowing about it.
He wasn't even in Florida. That's not your address.
And the other address that he has, that what they said that was the whatever was sent to, I've never stayed at that address in my life. I've never even known about the address.
You've been in Florida since 2009.
So if you want me to, I'll go hear other cases and come back, because you're telling me the same things that you already told me before. And that's okay. If you want to talk about that, that's okay. See, I told you, and the first thing that you started out saying, it makes sense to me. I'm not going to leave you under that $700 and something a month garnishment, because you told me earlier that you're working part-time. Then you added information that you're the sole breadwinner, that your wife has suffered with physical ailment, so on and so. I take all that into consideration. Okay, two things that are relevant here. Now, I could just leave that in place, but I don't want to do that, because I know that this has been going on for a long time, so on and so forth. The other thing that I know is that most of the judgment now is interest. So that's why I said, talk aside. Maybe you can come up with some agreement where you get some of that interest knocked off of there. We have a lower amount. That might be worth talking about. Okay, I can address today just the garnishment. You talk to the other side, maybe both of you could talk about what to do about some of that interest that has improved. Like I said, this started out as about a $2,000 judgment. It's $5,500. You had $3,500 in interest. So you may want to try to address that part. Then the final thing that I'll point out to you is that you can still file motions to try to get the judgment set aside from 15 years ago. The problem is it's 15 years ago. The problem is the thing that I described to you about what the files show. The files show legal service. The files show a alternate service that was allowed by a judge, not by me, but many, many years ago. And that established the way that this case would go forward. And that kind of ties my hands, okay? So that's the reason that you have the rulings that I made on the other issues. Now, I don't particularly like it, but that's the way that is. Now, the challenge is going forward. So my sense about this is based upon what you have communicated to me, that I would cap your payments at $200 a month, so it'd be $50 a week, and that would cap the payment. But what you want to try to do is figure out a way if you can reduce the overall balance based upon how long this has been. And so instead of taking $700 a month, it would be taking $200. You'd be going towards paying it. If you could discuss trying to get some of that interest taken off, then that's going to lead to you getting it paid off back. That's what I'm getting at. And again, if you see a way to try to get the judgment set aside, if I knew a way, but I really couldn't tell you because I can't give you legal advice. But if you find a way to get it set aside, I can't think of a way, but if you find a way, then I'll still be willing to hear that. But I just, today, based on everything I've seen, there's nothing I can do about that part. Okay?
Okay,
So let me do it this way. I've already told you that I'll reduce that payment to $200 a month, $50 a week. Let me,
Yes, sir.
let you talk with the other side and see if you can do anything about the interest on this. And if you do something about the interest, maybe you can figure out a more aggressive payment plan and that'll reduce the amount. I don't know, but talk with him for a moment and then come back in. I'm going to sign the order reducing your garnishment amount. But again, if you can get the others reduced, then that'll put you that much further ahead. You understand?
Yes, sir, I understand.
Okay, so let's try to do that part. And I'm sending you in with Mr. Johnson, and then come back in. Let's see if we can work on it further. Because again, I know it's been 15 years, and I know that most of that is interest. All right. All right.
Yes,
So click on into the breakout room, and then we'll talk on the other side.
Yes, sir.
Let me step back for a moment to Arrow Financial versus David Williams. The suffix in that matter is 5696. Welcome back, Mr. Johnson. Welcome back, Mr. Williams. Mr. Johnson, updating on things, sir.
Thank you, Your Honor. Mr. Williams and his wife graciously were in the breakout room. They gave me a proposal regarding the interest. I don't have approval for that at this time. They did give me an email address where I can communicate with them further. But yeah, we really have nothing on reducing the balance at this point.
All right. So I'm going to sign the order to allow for the garnishment to be reduced to up to $50 per pay. And that will reduce that amount. And sir, Mr. Johnson, they're going to hear back from you when regarding this matter.
I'm putting in their proposal to my client today, and as soon as I hear from my client regarding that, I will reach out to this email address and let them know, and then they can do the next steps, whatever those are. Hopefully they accept their proposal and we can just move on with this.
All right. So what I'll do is I will set a review date just so I can take another look at that issue, and I'm going to go ahead and set that up for April the 17th, 4/17/25 at 9:45. That's when it will come back in front of me. Let me take a look at it. Hopefully you guys get it worked out, and I'll take a look at it at that time. And in the meantime, Mr. Williams, you'll get an order from me limiting the amount of the garnishment to $50 per pay. And we'll send that to your payroll department. But when you get it, you make sure that you take it to them so that they can reduce it to the up to $50 per pay rather than the amount that is being taken there.
Yes, sir. How would I receive that?
I'm going to send it to you in mail at the address in Southville on Lindenwood Street.
I stay in Florida.
We sent in a correction of address.
I sent in a correction of address.
Yeah, the only address I have is the Southville address, and then I do have the address to the Auburndale, Florida address regarding.
Auburndale.
That's your job's address.
Sir?
Yeah, I have your job address. Let me see, just one moment. Just a second. 1 second. Okay, I do have something on, I believe it's 6 Lake Ida Street.
No, sir.
No, sir.
890 Winter Haven.
Excuse me?
I'm trying to figure out, well, wait a minute, I see a bunch of stuff. Okay, what about 35th Street?
Yes, sir.
That's
Okay,
correct.
That's in Winter Haven, correct?
Correct. Yes, sir.
Okay, I'll make sure that it gets sent to that address, sir.
Yes, sir.
All right, and then you have, you're gonna get something with the next date on this, just to try to deal with the interest of it. Not a whole lot I can do, but I wanna hear where the parties are and see if there's anything further that can be done. So I'll review it on the 17th of April.
Thank you, sir.
Receive an order from me in the next couple of days. All right, good day to you. Thank you, Council.
Thank you, sir.
Thank you, Your Honor. Thank you, Mr. Williams, Mr. and Mrs. Williams.
Thank
Yes, sir.
you.
Thank you, sir.
Good day to both.
Be safe, be well, sleep sweet, and much love.